The information in this video is for educational purposes only and is not legal advice. This channel is not a law firm and does not provide legal representation. Please consult a qualified immigration attorney for guidance specific to your situation and always verify the latest updates directly at travel.state.gov and uscis.gov. Vikram has been waiting for 11 years. He arrived in the United States from India in 2015 on an H-1B visa, started work at a software company in Seattle, built a career, bought a home, and had two children who were both born in Washington state. He filed his employment-based green card case in 2016. He has renewed his H-1B 4 times. His I-140 was approved years ago. His priority date has moved forward slowly, month after month, sometimes by weeks, sometimes by a single day, like watching a clock that barely moves. His wife Preeti stopped asking when it would finally happen. His children have grown up never knowing what it would feel like for their father to hold permanent status in the country where they were born. Every month, Vikram checks the visa bulletin the way some people check lottery numbers, with hope that is always a little smaller than the month before, and with a kind of exhausted patience that only people who have spent years inside this system can truly understand. Then last week, Vikram opened his phone and saw a notification from his immigration attorney. The message was short. It said, EB2. India is now officially unavailable. Not retrogressed, not pushed back by a few months. Unavailable. That single word, unavailable, means the United States government has officially used every EB2 immigrant visa allocated to Indian-born applicants for the entire fiscal year 2026. Every visa, gone. Used, and no new EB2 green cards can be issued to anyone born in India until October 1st, 2026, when a new fiscal year begins and a fresh quota of visa numbers becomes available. Vikram stared at that message for a long time. He was not panicking. He had been in this system long enough to know panic solves nothing. But he had one question, and it was the same question hundreds of thousands of Indian-born professionals across the United States are asking right now. What does this actually mean for my case, and what should I do next? That question is exactly what this video answers. If you are an Indian-born professional waiting for an employment-based green card, if you are on an H-1B, if you have an approved I-140, if you have been checking the visa bulletin every month for years, then the next 20 minutes may be the most important 20 minutes you spend this week. We are going to explain exactly what happened, why it happened, what it means for each type of applicant, what it does not mean, and most importantly, what you should be doing right now to protect your case while you wait for October. Let us start with the foundation, because to understand why EB2 India is now unavailable, you need to understand how the visa number system works, and specifically why a system that is supposed to issue 140,000 employment-based green cards every year still manages to run out of numbers for certain countries before the year is even over. The United States sets an annual cap on the number of employment-based immigrant visas that can be issued. For the entire world combined, that cap is at least 140,000 green cards per fiscal year, across all employment-based categories. EB1, EB2, EB3, EB4, and EB5. Within those categories, there is an additional rule that limits how many green cards any one country can receive. No single country can receive more than 7% of the total annual family-sponsored and employment-based green card limit combined. In practical terms for employment-based categories, that works out to roughly 9,800 green cards per country each year across all employment-based preference categories combined. Now think about what that means for India. India sends more H-1B workers to the United States than any other country in the world, by a very large margin. For decades, Indian-born professionals have filed employment-based green card petitions at a rate that far exceeds the 9,800 annual limit. The backlog has been growing for years, then for decades. People who filed petitions in 2012 are still waiting. People who filed in 2015 are still waiting. Demand is so far ahead of supply that priority dates for Indian-born EB2 applicants are measured not in months but in years, and in some cases in decades. What happened this month is that the Department of State and USCIS, which together track how quickly visa numbers are being used across different categories and countries, determined that India's prorated limit for EB2 immigrant visas in fiscal year 2026 has been reached. Every single EB2 visa number available to Indian-born applicants for this fiscal year has been allocated. The quota is exhausted. And under the law, once that quota is exhausted, the category becomes unavailable, meaning no new EB2 immigrant visas can be issued to individuals born in India until the next fiscal year begins. The fiscal year runs from October 1st to September 30th. The current fiscal year 2026 ends on September 30th, 2026. The new fiscal year 2027 begins on October 1st, 2026. That means for the next 3.5 months, from right now until October 1st, EB2, India is closed. No new visa issuances, no new green card approvals for Indian-born EB2 applicants through consular processing. No movement. The door is shut until October. Now let us talk about what this actually means for the different groups of people affected, because the impact is different depending on exactly where you are in your case. The first group, and the one facing the most immediate and concrete disruptions to you, is Indian-born EB2 applicants who are currently outside the United States and waiting for a consular interview and visa issuance. For this group, the unavailability is direct and immediate. U.S. embassies and consulates cannot issue EB2 immigrant visas to Indian-born applicants right now. If your consular interview was already scheduled and your priority date had become current, you may see your interview postponed or your visa issuance delayed until after October 1st. If you have not yet had your interview scheduled, the National Visa Center will hold your case until visa numbers become available again in the new fiscal year. This is not a denial. Your case has not been rejected or closed. It is simply waiting for the new fiscal year quota to open on October 1st. The second group is Indian-born EB2 applicants who are inside the United States and have already filed Form Y-485, the Adjustment of Status application. For this group, the situation is more complicated but also better protected. If you have already filed your I-485, your case is already in the Adjustment of Status queue, and your filing date and receipt are established. USCIS will not approve your case during the period when EB2 India is unavailable. They cannot issue the green card without an available visa number, but your place in line is preserved. You are not losing your position. The moment visa numbers become available again on October 1st, your case can move forward. During the unavailability period, you should continue maintaining your current non-immigrant status. And if you have employment authorization through your pending I-485 filing, that authorization continues. The critical thing for this group is not to do anything that would disrupt your pending case. Do not travel internationally without first confirming your advance parole document is valid. Do not change employers without understanding the implications for your I-140 portability, and respond promptly to any USCIS requests for evidence or information. The third group is Indian-born EB2 applicants who already have an approved I-140 but have not yet filed their I-485 because their priority date was not current. For this group, the unavailability changes very little in the immediate term because you were not eligible to file yet anyway. Your situation remains the same as it was before the unavailability. You are waiting for your priority date to become current and for visa numbers to be available. The important thing to understand is that when October 1st arrives and the new fiscal year quota opens, the EB2 India dates will reset with new numbers. What those dates will be in October is not yet certain. It depends on how the Department of State manages the transition and how many numbers carry over. Watch the October 2026 Visa Bulletin carefully because that bulletin will tell you the new EB2 India cutoff dates for fiscal year 2027. The fourth group is perhaps the most anxious, and with good reason. These are Indian-born EB2 applicants who were just on the edge of having a current priority date when the unavailability was announced. People whose dates were very close to the final action cutoff and who were expecting to file their I-485 or receive their visa within the next few months. For this group, the unavailability has pushed the opportunity back to October at the earliest, If you were within weeks or months of being able to file your I-485, based on the recent visa bulletin movement, you will now need to wait until October 1st for the new fiscal year quota to open and for the new cutoff dates to be published. That is genuinely painful after years of waiting, and there is no sense pretending otherwise. But it is also not a permanent setback. October 1st will bring new numbers and new movement. Use this waiting period to make sure every part of your case is ready. Now let us address something that is causing enormous confusion online right now. And it is a point that needs to be stated with complete precision, because getting it wrong leads to bad decisions. The EB2, India unavailability, does not affect your approved I-14. Oh, petition in any way. Your I-14O approval is permanent. It locks in your priority date. It establishes your place in line. An approved I-14O does not expire because of visa number unavailability. It does not need to be refiled. It does not lose validity during the period when EB2 is unavailable. Your I-140 is your anchor, and it stays exactly where it is through October and beyond. The unavailability only affects when you can take the final step, filing your I-485 or getting your immigrant visa issued, not your underlying eligibility or your position in the queue. Protect your I-14. O by maintaining lawful status, by not taking any action that would make you inadmissible, and by keeping your employer relationship intact if your green card is employer-sponsored. That approved. I-14. O represents years of effort, and nothing about the current unavailability touches it. There is something else buried inside the June 2026 visa bulletin that almost nobody is talking about, and it matters enormously for what comes next. The Department of State included an explicit warning in the June bulletin, a warning that applies not just to EB2 India, but potentially to EB1 India as well. The bulletin says directly that high demand and number use by Indian-born applicants in the EB1 and EB2 categories made it necessary to retrogress the final action dates to keep number use within the fiscal year 2026 annual limit. And it says that further retrogressions or making the categories unavailable may be necessary in the coming months if India's prorated limits are reached. EB2 has now officially become unavailable, as we have discussed, but that warning about EB1 India is still very much on the table. EB1 India retrogressed significantly in the June bulletin, moving back 3.5 months to December 15, 2022. If demand continues at the current pace, EB1 India could face additional retrogression, or even its own unavailability declaration, before September 30th. If you are an Indian-born EB1 applicant, whether through extraordinary ability, outstanding professor or researcher status, or multinational manager or executive status, you need to watch the July 2026 visa bulletin very carefully when it is released, and you need to speak with your attorney about whether there are any steps you should take before the fiscal year ends. Let us also talk about something practical that many people do not think about when visa numbers become unavailable: the interaction between H-1B status and this unavailability period. Many Indian-born EB2 applicants are currently in the United States on H-1B status, with their I-140 approved and their green card process underway. The unavailability period does not change your H-1B status. Your H-1B remains valid for its authorized period. You can continue working for your sponsoring employer. You can renew your H-1B when renewal comes due. And importantly, if you have an approved I-14. Oh, that has been approved for 365 days or more? You may be eligible for H-1B renewals in 3-year increments beyond the normal 6-year cap under the American Competitiveness in the 21st Century Act, commonly known as AC-21. This 3-year renewal provision is one of the most valuable protections available to Indian-born H-1B workers who are stuck in the green card backlog. And if you are not already using it, now is the time to discuss it with your attorney. And speaking of AC-21, the job portability provisions of AC-21 are just as important during this waiting period. If your I-485 has been pending for 180 days or more, or if your I-140 has been approved for at least 180 days, you may have flexibility to change employers or positions without abandoning your green card case, as long as the new role is in the same or similar occupational classification. The unavailability period, while frustrating, is actually a reasonable time to evaluate your career options, because your case will not be adjudicated during this period anyway. If you have been in a role that does not fully use your skills, or if you have received an offer from another employer, this 3.5-month window before October 1st is a good time to have a careful conversation with your immigration attorney about whether a job change is possible and what it would require. Here is the most important thing you need to take away from this video, and it is something Vikram's attorney told him in the same message where they delivered the unavailability news. October 1st is not the end of the story. It is, in a very real sense, a reset. When the new fiscal year begins on October 1st, 2026, a new annual quota of EB-2 immigrant visas for Indian-born applicants becomes available. The Department of State will publish the October 2026 Visa Bulletin, which typically comes out in mid to late September, and that bulletin will show the new EB-2 India final action dates for fiscal year 2027. Based on normal patterns and the enormous backlog of applicants whose cases are ready and waiting, immigration attorneys expect meaningful forward movement in the October bulletin for EB-2 India. Exactly how much movement and exactly what the new dates will be depends on factors that will only become clear once the October bulletin is released. But the door will open again, the quota will reset, and cases that have been waiting through this unavailability period will be among the first in line to move forward. So here's what Vikram is doing right now, and here is what you should be doing too. He is not panicking. He is not withdrawing any applications. He is not making impulsive decisions about leaving his employer or abandoning his green card process. He is maintaining his H-1B status carefully, making sure every renewal is filed on time and that there are no gaps in his work authorization. He is working with his attorney to make sure every document in his I-485 file is current. His address with USCIS is updated, his medical examination has not expired, and his employer verification is current. He is setting a reminder for mid-September when the October 2026 Visa Bulletin is expected to be released, so he can review the new EB-2 India dates the moment they are published. And he is watching this channel for updates because the moment the October Bulletin comes out, we will break down exactly what it means for Indian-born EB-2 applicants and what the path forward looks like. If you want to be among the first to get that update, subscribe right now and turn on the notification bell, because that October bulletin is going to be one of the most important pieces of immigration news for hundreds of thousands of people this year. The EB-2. India unavailability is real. It is frustrating. It is another chapter in a backlog story that should not exist in a country that relies as heavily on skilled immigrant professionals as the United States does. But it is also temporary. October 1st is coming. The quota will reset. Your I-140 is safe. Your place in line is preserved, and the best thing you can do between now and then is exactly what Vikram is doing. Stay informed, stay compliant, stay patient, and be ready to move the moment the door opens again.